the judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Please be seated.
Good afternoon, everyone, and welcome to the Court of Appeals. We are very happy to be here at Campbell for one of our very special away sessions. We didn't get to have these for a couple of years, so it's very exciting to be back here to see everyone in person. Your panel today you've actually got an extra bonus today, okay? We have two cases for argument, and on the first case, your panel, of course, will be me, Chief Judge Stroud, Judge Don Tyson to my right, and Judge Toby Hampson to my left. We are all Campbell Law School judges. And for our second case, actually our panel is going to switch, so we're going to take a recess between the two cases to switch out the panels, and Judge Carpenter is going to join the panel, also a Campbell judge. So you get 4 Campbell judges today at Campbell. We had a change in the schedule. We generally try to have 2 cases on our calendar for the law school sessions, a criminal and a civil, and our second case very recently settled, which is great. But then we also had to find another case. So we really appreciate the attorneys in the second case agreeing to have the argument today. That worked out very nicely for the court and for the students at Campbell, because it's also a very interesting case that I think they will really enjoy hearing. So. And then since we do have the 2 panels, one of the things we normally do after arguments is take a little bit of time to answer questions or whatever from students. Of course, not about the cases, but about other stuff about the court or whatever. So we will do that after the second case, and I'm assuming all 4 of the judges will participate, but anyway, we'll do it after the second case. So. All right, so it looks like we are ready to proceed with the first case, State v. Ambriz. And I'm sorry we don't have the little timer lights here at this courtroom, but we will be trying to keep up with the time. And, yep, all right.
Thank you. Good afternoon. May it please the court, I'm Kathy Vandenberg with the Appellate Defender's Office. I'm here today on behalf of Mr. Ambriz, and I'd like to save 10 minutes for rebuttal. The state did not offer substantial evidence that Mr. Ambriz planned, aided, or encouraged this drug deal, and the state violated Mr. Ambriz's constitutional right to a speedy trial under the factors set out in Barber. For both of these reasons, the law requires that his convictions be vacated. I'd like to spend a few minutes on sufficiency and then switch over to the speedy trial. Substantial evidence exists if a rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. That's from State versus Campbell. I think what sometimes gets lost in that definition is the clause about beyond a reasonable doubt. The state cannot just show any evidence of each element. They have to show substantial evidence, and that word has to be given some meaning. And in this case, the state did not meet that burden. What they offered amounted to speculation. The state's brief and their argument at trial essentially relied on Mr. Ambriz's presence. He was in the car, he was hanging around with other people who were doing the drug deal. And we know from our case law that mere presence isn't enough. The state also relied on propensity. There's some evidence that he was talking about doing other drug deals with these people and perhaps convincing the driver of the car to be involved in other drug deals with him in the future.
So in ruling on a motion to dismiss for the sufficiency of the evidence. Is it necessary for a trial judge to only look at sort of, direct concrete evidence, or cannot a trial judge look to the circumstantial evidence as well and draw reasonable inferences in favor of the state from that circumstantial evidence?
Yes. The trial or the appellate court and the trial judge look at evidence as if it was true, and they can draw reasonable inferences. But that still has to total up to substantial evidence that can convince a rational juror beyond a reasonable doubt of guilt.
But you would agree, this is one area perhaps in criminal law where the law is perhaps a little more deferential to the state in terms of our standard of review, in that, if there's a question, the motion to dismiss is denied and it goes to the jury. Would you agree with that?
I would not agree with that, because speculation is a question. I mean, I can say the very thinnest scrap of evidence, and someone can say, well, that's enough to raise a question. The question isn't enough. That's speculating. You can have theories. Maybe Mr. Ambriz was involved in this drug deal and he just never said anything out loud about it, or maybe this or maybe that. That's speculation, and our case law does not allow a conviction under that circumstance.
Ms. Vandenberg, your client, the counsel for the state, throughout his brief, cites the Supreme Court's case in State versus Golder, and that was a 2020 case where the Supreme Court addressed this very issue on the sufficiency of them. Do you want to try to distinguish that case, or do you want to ask why that case would not bind us here?
I'd be glad to. I actually think State versus Glover helps Mr. Ambriz. In Glover, it's a...
No, this is Golder.
Oh,
G-O-L-D-E, or Golder.
Okay.
2020.
Can you tell me specifically what in Golder you're looking at?
Well, the Supreme Court said in evaluating the sufficiency of the evidence must be considered the light most favorable to the state. The state's entitled to every reasonable inference and every reasonable intent and every reasonable inference to be drawn therefrom.
Right. So what I'm arguing about is what's a reasonable inference, and what reasonable inference can get you to substantial evidence.
Well, your client's been tried 3 times.
Correct.
And on 3 times, the evidence went to the jury.
Correct. And 2 out of 3 of those juries found there was not evidence beyond a reasonable doubt.
Well, they found that they hung up, that there was a mistrial, correct?
Correct.
And the state chose to retry them.
Correct.
So it's passed the test of sufficiency 3 times, correct?
Well, I disagree with that. It's passed the trial court's judgment about the sufficiency. And if the test were if any jury could ever find this person guilty, then we'd never have appellate review of sufficiency, right? You just say, well, the jury found him guilty, so it must be sufficient. That can't be the test, or there wouldn't be appellate review.
What would you propose that we use then, if we were looking at what the trial court did or what the jury did?
Well, it's de novo review on sufficiency claims. So you substitute your judgment for the trial court, and then the test from Campbell. Is there substantial evidence that exists that a rational trier of fact could have found the elements beyond a reasonable doubt? Not any evidence that might support speculative theories about maybe he did, but actual evidence.
And do you have a recent case where either this court or the Supreme Court has applied a stricter standard to the evidence than what Golder did?
I think Golder is the same standard as I just read it from Campbell. It's just a different way of putting it. And the case that I wanted to talk about a second ago was Glover. And in that case, there's a guy charged with possession of heroin. It's found in his dresser in a house where he lives. It's not in his room, but out in the hall. But it was agreed that that was his dresser. His housemate had a tin of heroin. He knew that she had a tin of heroin. He had used heroin with his housemate before. What he didn't know was that the tin of heroin had been placed in his dresser. So I know it's not the exact same facts as we have here, but you have, knowledge, right? If Mr. Ambriz has knowledge that there's a drug deal going on, the guy in Glover also had knowledge that there was possession of heroin going on in his house. And what was missing was evidence to show that he and the other housemen had a common plan to actually possess it together. And this is an acting in concert theory. And in this case, Mr. Ambriz, even if he knew there was a drug deal going on, there has to be evidence that he took an action of some sort and that he had a common plan with the other people who were doing the drug deal. And I don't believe the state was able to put on that.
But you would concede that a lot of times there isn't necessarily direct evidence of that common plan, right? There's not going to be a written contract to commit the crime. A lot of times that has to be shown through this sort of circumstantial evidence.
But the circumstantial evidence cannot just be mere presence. That's well-established case law.
It wasn't just mere presence at some single scene of a crime. I mean, he was in the restaurant, left the restaurant, got in the car, went to the warehouse, got back in the car, went back to the restaurant, where the deal was ultimately sort of
He was present
consummated.
the whole time, absolutely. And mere presence is not enough. He has to have taken an act to further this drug deal in some way, and there has to be evidence that he had a common plan.
Is leaving the restaurant and getting in the car an act?
I think that's presence. He's staying with the people he's with. And you could speculate, we're talking about what's substantial or not. I mean, yes, he was there. Yes, he went around with them. And after the drugs were dropped off, they all went out shopping and they went out to eat together and hung around until, such time as they thought the deal was going to happen. And I contend that's their presence. I'll move on to speedy trial. The court's well aware there are 4 factors for speedy trial. The length of the delay, the reason for the delay, the assertion of the right, and prejudice. The first thing this court might get caught on that we've argued in the briefs is how to count the length of delay when there's been a mistrial. I have argued that you count the entire time, 5+ years. The state has argued you reset every time there's a mistrial. And I've got 3 reasons that my interpretation is correct. One is State versus Carvalho. Judge Tyson may have something to tell us about that, but in that case there were 9 years that went by and there were mistrials, and in analyzing the speedy trial, this court looked at the entire time as one length. The second thing...
There were four trials in that case, right? 4 first-degree murder trials with 2 different victims.
Yeah, complicated, right?
And there were negotiations for plea arrangements, and he also served an intermediate sentence for an unrelated crime for 3 years.
Right. It was very complicated, a lot of different factors. And I think just logically and as a matter of policy that, this is in the reply brief, that it makes more sense to look at it as one big long time and then look at the reason for the delay. Well, part of the reason was a trial happened and then we had to wait a little while, and part of the reason was this or that. And that way you can look at really who's responsible for the delay. Mr. Ambriz is certainly not responsible for the jury not agreeing on evidence and having to be retried. And the other thing that I didn't cite in the brief but I ran across preparing for this argument, I did cite the case but for a different proposition. It's a U.S. case, Fetterman versus Montana. And that case was a federal trial, and the argument was after the person had been convicted, there was a long period of time before that person was sentenced. And they were trying to argue, the defense was that time between conviction and sentence should also be included in the speedy trial analysis. And the court said, no, that's not right. It's conviction that ends. And the language they use, I think, is instructive here. It says, a presumptively innocent person, until found guilty, right, should not languish under an unresolved charge. They say the presumptively innocent are protected by the Speedy Trial Clause from long enduring unresolved criminal charges. The Sixth Amendment does not extend, or a speedy trial right does not extend beyond conviction, which terminates the presumption of innocence. So they're looking at the uncertainty, the unknowing, I still have these charges hanging over my head until there's been a conviction. Not until there's been the first witness sworn at trial or some other test.
The third factor, or the fourth factor, is what actions the defendant took to seek the speedy trial.
Right.
And if they were complicit in plea negotiations or delays, and how quickly they asserted that right. Do you want to speak to the third factor?
Sure. There were 4 speedy trial motions by counsel. There were 2.
As it relates to this trial, the final trial? Or
Well, there were 4 along the way. And Mr. Ambriz himself filed his own pro se motion to start this speedy trial, and then later, after the first trial, wrote a letter, and this is at record page 40. And I cited a little bit of this, but I just wanted to let you hear the whole thing. Over 6 months ago, he says to Judge Davis, I was finally given a trial which resulted in a hung jury. 2 years prior to this trial, I have repeatedly informed Mr. Zellmer, who is his lawyer, I wanted a speedy trial to prove I'm innocent of the charges. Mr. Zellmer replied each time by stating I would have to wait on the DA. Since my trial over 6 months ago, I've once again informed my attorney that I want a new trial. My family calls and tells my attorney that I want a new trial. He responds by saying there's nothing he can do. That I have to wait on the DA. My family searched online and found that this is untrue. My attorney can file various motions with the court to speed up the process. So Mr. Ambriz, from the very beginning, wanted his trial, wanted his day in court. After the jury hung, he wanted his trial again. He was ready to get out of jail. He sat there for 5+ years. And
that letter's not dated, is it?
It is not dated. There's a response to it from the court on October 31st. So I think I said in the brief that, probably it was written in October of 2018.
And this trial occurred, this last trial occurred when?
May of 2021.
Was this letter in response to the latest trial or?
No, this was after the first mistrial. So first trial was April 2018, and this is 6 months after that, in which he does say in here, 6 months ago.
So can you tell us what actions he may have taken after the second mistrial to assert the speedy trial right?
Well, his lawyer filed a third motion and a fourth motion. And COVID came along in the middle of that, and we can talk about that, but I don't see how the assertion factor can weigh against him, and in fact, I think the state conceded that it does.
Well, you made that statement in your brief, but I wanted the timelines because I didn't know how many of those were asserted in prior actions as opposed to what he had done, and then how quickly the state responded on this trial. That was the reason for my question.
Sure. And there's at the end of the brief, there's a timeline too, I think, that has all of that set out at the end of my initial brief. So we talked about the length of delay and the assertion of the right. The reason for delay, I contend, also weighs in Mr. Ambriz's favor. The prosecutor, every time they had one of these hearings, he would talk about there were 4 co-defendants, and it was really hard, and I wanted to, do it in my certain order in order to, make this work the best for me. Those are not fair reasons to Mr. Ambriz. It's not, you don't have to try one person at a time. You can try them all, back to back. And it's not Mr. Ambriz's fault that he was chosen to go last. That was a conscious, intentional choice by the prosecutor, presumably for his own reasons. He also, the prosecutor, continued to talk about plea offers. Before, Mr. Ambriz was arrested in 2016, and by summer of 2017, so it's almost a year and a half, they have a status hearing or something, and they talk about a plea offer, and Mr. Ambriz says, I don't want a plea, I want to go to trial. This is early on. And the state says, okay, I hear you, we're going to set this for trial next month or in October of 2017. And that time just goes by, and there's never an explanation. Why aren't we at trial? And then in November, he comes back and says, well, I made a better plea offer, and I'm going to put it on the record why there's not been, why he doesn't want to take it, or for whatever his reasons are, and still hasn't prepared for trial. And Mr. Ambriz says, again, I'm not interested in a plea. And then more months go by, and the prosecutor still hasn't, calendared the case. And, I've often read transcripts where the trial is happening, and right at the outset, the prosecutor will say, well, I want to put on the record that this plea deal is being turned down. And they do that, and then they go ahead and have the trial. He doesn't give a reason why he kept putting it off. And I think you can infer that he didn't want to try this case because it was not a good case. He said that a couple of times in a couple of these hearings. I recognize that the evidence is not, as strong against Mr. Ambriz as some of the other people. And the fact that he continues to use the plea bargaining as an excuse when Mr. Ambriz has very clearly said he's not interested weighs heavily against the state. It's certainly not Mr. Ambriz slowing things down. There are cases where there's plea negotiation on both sides, and the defendant says, give us a little more time, I think we can work something out. That is not this case. And then the third thing that happens is, so those are two choices by the prosecutor. What order to try the cases and putting it on the calendar. And the third thing that happens to delay is preparation of the transcript after the mistrials. And that is not Mr. Ambriz's responsibility. That's the state's responsibility. And if it takes 8 months to get a couple of pages of testimony transcribed, that is on North Carolina. If the court reporters are too busy, someone should fund them so that they can get that done.
Your timeline says that there was a motion to dismiss an alternative for a speedy trial on January of 2021. And the hearing was held the following month, February the 11th.
Right.
And the trial was originally set for March 15th, but then it was actually held in May.
And
Is there any explanation for that continuance?
Yeah, the defense counsel had some kind of a medical issue. So when the trial was finally called, they mentioned that. Again, not the state's fault, but also not Mr. Ambriz's fault that his lawyer, I don't know what it was. I mean, obviously if he was sick, he couldn't do the trial. But at best, that's a neutral factor.
You would agree that would not weigh against either party. That's just a factor that 2 months, additional months would not count.
Right. And I think the best point to look at, that Mr. Ambriz had the strongest case at that February 2021 hearing. He'd been in prison the longest amount of time, the state had delayed the longest amount of time. And at that hearing, the trial court didn't make any findings as well. And it, in terms of remedy, it's a little tricky because there are 4 separate hearings. There's only one where any findings were made, and that was the third one. So is that moot because of the fourth one? Can you remand for findings from the very first hearing?
Well, that was going to be my question, because when you contrast, the last order with Judge Morgan's order from 2019, which is pretty, full of findings and explanations and weighing the factors versus the very summary order. Right. I guess I do sort of have a question as to remedy. Is there a need to remand this for findings of fact? And
right. So my position is there's plenty in the record that you have before you to show what the state's reasons were, to show the timeline. You've got all the motions that have been filed, and you've got transcript hearings from each of the speedy trial hearings, and I think there's plenty there. I disagree with I can go through the facts and the conclusions from the third iteration of the speedy trial motion, but it's in the brief. I just disagreed with the findings, basically. I think they're supported.
And sort of thinking about this, sort of assuming without deciding, we were kind of take these things seriatim and not look at the whole piece. Would you argue that there is, in even looking at the last motion, were we to look at that sort of on its own following the last mistrial, Is there room within those factors to consider the prior delays and the prior mistrials as well? Even if if we didn't calculate the full length of time based on that, would that not be a consideration in looking at the speedy trial analysis, even in that last order?
I hope so. I mean, Mr. Ambriz was in jail that whole time. You know, you can't erase those prior years where he sat there waiting and trying to.
Carvalho, who was in jail for 9 years, and the U.S. Supreme Court said no speedy trial violation. It went all the way up.
Right, and I mean, every case is different, right? Every case has different factors. I know in Carvalho, the reason for delay was very different, and there were things that were attributable to him and other complications. That's not true in this case.
There was a motion filed in September of 2020 where your client's counsel had asked for the continuance, correct?
Well, if you look at the transcript of that hearing, he was asking for bond. He was trying to get Mr. Ambriz released because it's in the record, you know, that he's got a sentence that he has to go serve, after which he'll probably be deported. He could have served that twice by now, you know, but he can't start until he's finished in North Carolina. So that's one of the prejudice factors. But that hearing was supposed to be about bond and trying to get, allowing Mr. Ambriz to go do his federal time while we're waiting around for this plea transcript or whatever they were waiting for. And then they started talking about this co-defendant's NAR, and it got very complicated. And then the judge said, let's go in chambers. And they did, and that's all off the record. And then they come back and say, well, we're just going to kind of table all of this. And then in his written findings, he said defense counsel agreed to a continuance, and I think that's not exactly
Here's what it says. It says defense makes a motion to continue if the state's not opposed.
Yeah.
That's what the order says.
Well, that's what the order says. And if you read the transcript, that's not what happened, unless, I don't know what happened in chambers. And the other thing I'd say is Mr. Ambriz definitely was not agreeing with that. Even if his lawyer went into chambers and did I don't know what happened there. But
The proper way to attack that would be through a motion for ineffective assistance of counsel and not through a sufficiency motion, correct?
Well, sufficiency motion, speedy trial motion. I mean, there's some language in some of the U.S. cases talking about the difference between a defendant and what his lawyer does. And I would say, especially for a court-appointed lawyer, you know, what's Mr. Ambriz supposed to do? You know, if he tries to fire his lawyer, that counts against him in speedy trial analysis because you have to start all over again. I think he's happy with his lawyer. I mean, he got the jury hung twice. He just wanted his trial, and he didn't get it for 5+ years.
Okay.
I'm going to save the rest of my
Right,
time.
okay,
Thank you.
yeah. You were in the middle of questions there when you're done, so I'll give you a little leeway on that.
Okay, thank you.
Great.
Good afternoon, Madam Chief Judge, and may it please the court. My name is Caden Hayes. I'm with the North Carolina Department of Justice, and I am representing the state in this matter. Your Honor, as you've heard, as you've read in the briefs, there are two issues at play here. The sufficiency of the evidence under supporting the jury's guilty verdict, and whether or not the state violated the defendant's speedy trial rights. I want to briefly touch on sufficiency, as that seems to be the bulk of the discussion seems to be about speedy trial. But I think it's important that we analyze the context and the facts preceding, or more specifically the evidence at play here. We have a CI who gets information about a large interstate drug operation. He negotiates with this operation and also relays back this information to his handler. And a meet is set up on February 6th. They put the money in the bag. One of the members of the operation, I think his nickname is Paco, comes in, looks at it, seemingly happy, makes a call, and then says, "Driver's in Alabama, we'll reconvene at another time." That same night, the defendant gets a text from a different member of this organization saying he's in Alabama, and the defendant responds, "It's okay, go." Then next morning, now the defendant's there, along with Paco, this individual named Ambriz, who's the one who texted, who's the one who's also involved here. They walk out of the La Fiesta looking for somebody to arrive. The driver arrives with roughly 20,000 units of meth, individual doses of meth, in his trunk. The defendant and Reyes get in the car, and they drive off in tandem to the storage unit. In the car, the defendant tries to convince the driver to work for him instead, citing better connections, a truck that has better smuggling equipment within it. And we get to the storage unit. Reyes asks the defendant to move the meth. And while it's unclear if he did try the handle, we know the child lock was on, and it was a reasonable inference that he did, and that's how they figured it out. The defendant, in a lot of their arguments today and in their brief, said that he's just a passive bystander. He didn't make an action. Well, that is an action. Attempting to get out of the car to move methamphetamine from the trunk to the garage. And then they drive off to a nearby gas station. The driver leaves and goes to a Home Depot with his son. Everyone else goes to a restaurant, has lunch, and they wait for the money to arrive. When it does arrive, the defendant, with everybody else, except for the driver who's still at Home Depot, comes back where he is arrested. Which brings us now to this question of sufficiency. And certainly this is a circumstantial case. As Judge Hampson pointed out, very rarely do we have like direct evidence of a contract or something a little crazy like that. We have text messages that corroborate with what a different member of this conspiracy said to others about a driver being in Alabama. We then have the next morning him arriving, jumping in the car with the drugs, the driver, and member of this operation. He is asked to move the methamphetamine from the trunk to the storage unit. And then he leaves and then comes back with everybody to collect the money. At some point, we have to say this is sufficient evidence because there's all of these steps that he is taking to be along this kind of drug transaction.
So it strikes me that there's not so much a factual dispute in this case, but rather it's sort of the standard that we need to apply to those facts, and in terms of what constitutes sufficient evidence to survive a motion to dismiss. I guess in between there's sort of the line between where do we draw the line between an inference that may be reasonably drawn from the evidence and a speculative theory of what that evidence may show, and how would the state articulate the standard to apply on that?
Well, Your Honor, reasonable would be a just kind of common sense reasonable. What is the next logical step? I will use the child lock example. It's very unlikely that they just remembered in the midst of a massive drug deal, oh, right, I have my child lock on. It makes more sense that he tried the handle and it didn't open, rather than him coming to terms with this driver. And so something like that would be a reasonable inference, whereas, I don't know, if he said the child lock was on, I'm struggling to come up with a very speculative theory, but there are in that idea of wholly not based on the evidence, doesn't make sense from a common sense perspective, then we're moving beyond kind of reasonableness, and we're now into speculation. If for example, let's say, Reyes had not instructed the defendant to get out of the car and move the meth, well, maybe it's a little more speculative, because we don't know if he tried. He had no reason to try that door handle, because he wasn't as far as when he was getting out. But that's not the case here. We have Reyes instructing the defendant to get out of the car, move the methamphetamine. And so we have all of these layers of circumstantial evidence that all kind of combine together to make this idea that the defendant was in conspiracy with the other members here, and he was, by that same evidence, controlling the drugs constructively and also enacting consular theories as kind of laid out in the briefs. And this circumstantial evidence is wholly appropriate. We can look at State v. Howell, that's kind of that idea. And also State v. Lawrence talks about how there are innocent acts that may seem innocent individually, whereas I think the heroin tent that we were talking about earlier, those all kind of seem a little more innocent than very little acts. But when taken together, it's a bigger deal, which is what we have here, which maybe we didn't have. I believe it was Glover. So, in short, the state presented sufficient evidence to convince the jury that the defendant was involved in this drug deal and he possessed the drugs in question. So with sufficiency out of the way, I now want to talk more about the speedy trial process.
Let me ask you this. What else could the defendant have done that he didn't do?
In terms of sufficiency?
No, on speedy trial.
Well, Your Honor, he presented this, but I think the most important thing, which I'll get to as prejudice and also as reason for delay, he never presented any evidence at any of these hearings. He just proffered statements that aren't proper evidence before the court. No one was called. He didn't even certify the motions themselves. So the court was left with nothing other than this delay, which there are case law from our Supreme Court that says longer delays are not enough by themselves to win a speedy trial motion. And so with this in mind, we can kind of look at this first of the four Barker standards or factors.
Well, I mean, there are problematic issues with having a criminal defendant testify during pretrial motions. Are there not?
Well, certainly there are, but there are other ways that the defendant could have said something. He could have talked about how his defense was hampered or how the state had done anything to be willfully misconduct. I mean, even he could have said that I will never want a plea negotiation, will never want a plea offer. All we have is this one undated letter that, frankly, the court shouldn't be considering because it was a pro se letter when he was represented by counsel. And so there were a lot of things that the defendant could have done. But by and large, that question presumes that he's violated, or the state violated his speedy trial rights, which the state hasn't. In fact, he was granted 3 trials over the course of 3 years. And so we can now, this brings up that kind of first issue of when does the speedy trial, or does it at all restart? And I want to, on the outset, note that the defendants in their opening brief only addressed this in a footnote citing Carl Howe, which didn't strictly discuss the issue as the state's brief discusses. And so the state's position is defendants waived argument on this issue. But putting that aside, moving on to the actual substance, the absolute canon, the bottom level canon of statutory interpretation, which is what this is common sense, what the words mean as they are, not what they should mean or what we want them to mean. The right to a speedy trial is just that. You have a right to a speedy trial, not a speedy adjudication, not a speedy final disposition. The state has control over the jury or the trial calendar, but the state has absolutely no control over the votes themselves. And so it makes sense applying that common sense interpretation of the language to just restart with every mistrial. Now, the defendant in...
But fundamentally, we have these rights, these speedy trial rights, double jeopardy rights. They all sort of stem, right, from defending a criminal defendant, against the overwhelming power of the state, right? I mean, it all stems from, the English practice of keeping defendants kind of hanging around until you could find, a more favorable jury. So why, surely at some point, the length of time, the number of mistrials, and there were not insignificant gaps between each individual trial here. Like, surely at some point it has to amount to a speedy trial violation.
Well, maybe you are, but that didn't happen here. I think, yes, there were some gaps in between the individual, but as we kind of discussed, I'll get into is the second problem. There were valid reasons for that. There was the jury transcript that the defendant requested that took 8 months to produce, and then they got it around Christmas time, and then they asked for a continuance for 2 months. And so the reality is the state only delayed the case by a couple months once you take out that between the first and second trial. Between the second and third, we had COVID, and we had so many other issues stem up during that were fully addressed in the hearings and the discussions of the trial court. And so
the state's desire to try him with co-defendants, how should we look at that in terms of any delay that caused?
the state is given its prerogative in order to decide how it wants to proceed with cases. There's a case from our Supreme Court called State v. Cherry, which talks about how there may be selectivity in prosecutions, but the exercise of this prosecutorial prerogative does not reach constitutional proportion unless there's some showing that there's some that was deliberately based on unjustifiable standard, race, religion, or some other arbitrary metric.
So there's a motion to join for trial and then a motion for separate trials that's denied. Is the defendant then barred from asserting a separate speedy trial by virtue of the joint being ruled on?
Well, the defendant's allowed to assert his speedy trial rights whenever he wants. Whether or not they've been actually violated is a different question. The joint motion was there.
How long was too much?
For a speedy trial? I think the hallmark of speedy trial litigation is there is no magic number. Certainly, as the defendant points out in the reply brief, there's a U.S. Supreme Court case called State v. Doggett where it was almost 9 years, but as you point out to Carl Howe, that was also around 9 years. And so they were very different. There's no magic number.
Do we have, correct me if I'm wrong, but my recollection is that we do have some case law in North Carolina that does talk sort of about a prima facie speedy trial number.
Yeah. So the most recent being State v. Spinks, which I think Chief Judge Stroud authored. That, yes, it said, I think 31 months was the shortest month it highlighted. Two things on that. One, there is no point in this litigation where 31 months elapsed between indictment, first trial, second, third.
Isn't prejudice presumed after a year in some of the cases?
Yes, Your Honor, but prejudice presumed in that language is a bit of a misnomer. It's in the sense, it's a different analysis than saying the prejudice prong of Barker. All we're saying when we say the prejudice presumed in that context is just that we can continue the analysis.
Wouldn't that shift the burden to the state to explain the reason for delay?
Well, Your Honor, I would disagree. There is
If you have a presumption, then doesn't that shift burdens?
Well, Your Honor, I think that's a bit of a misnomer by the U.S. Supreme Court. They have been clear, and our Supreme Court
They
has also...
may be wrong, but they're still the Supreme Court.
Certainly.
You can tell them that.
But I, in the sense of, they say prejudice in that way, but they've consistently held that that is just the threshold analysis, that we can start talking about Barkers when you say it's presumptively prejudicial.
Well, let me ask you this. Let's say that the defendant comes and says, I've been in prison, I've been in jail for a year, and I want a trial, I have it. What happens then if the state says, too bad? What does the judge do?
Well, Your Honor, we get back to that kind of state v. Cherry of the prosecution. State's allowed some discretion to be able to decide how it decides its cases and which cases it puts on first. And until we show some sort of more, I lack of a better term, evil or incorrect way to approach that the state has done, we haven't had a speedy trial violation. And certainly when it comes to cases like this, where we have multiple states, the federal government is having to do analysis, and there's multiple defendants, a year is not nearly enough to really fully encapsulate all of that, given the state's resources and the judicial's resources. And so, taking us back to kind of this first prong, it is important, I think, that we reset the timer with every hung jury. And I want to briefly address the parade of horribles defendant puts in the reply brief, that there's all sorts of reasons that a mistrial could occur. Witness blurts out something, some sort of discontent by either counsel. That is a little different because a hung jury is quite literally the last part of the trial. The speedy trial is important for a defendant to show, potentially prove their innocence. It is not, so when you have a hung jury, that's what they've done. The defendant has had his entire case presented, and the jury decided they can't decide. When we move on, so it makes sense. Maybe if there was some prosecutorial misconduct, certainly then, maybe we don't reset the timer. But for hung juries, we should reset the timer. And that logically makes sense, following the kind of language of the speedy trial constitutional provision. And so...
let me ask you a question. Actually, when you said that, that reminded me of something I had noted in the brief. It said that the right to speedy trial works to ensure an accused can receive his day in court and perhaps prove his innocence. I didn't know the defendants had to prove their innocence. I thought it was the other way around.
Well, certainly, Your Honor, I guess I could have probably honed that in a little bit better, in the sense of the defendant can put forward evidence rebutting the state's case, in the sense of we want to make sure that the state can't just hold somebody forever and ever without a trial. There's so many constitutional protections, as Judge Hanson was pointing out, to ensure that doesn't happen. Speedy trial is just one of them. And
So if we, as far as looking at reasons for the delay, obviously in this case we have trials, we have mistrials. And the reasons for the mistrials were certainly not anything that were just outside of, it was not like a witness or a juror got sick or things that we could just say stuff happens and, there's nobody had any control over it. There were hung juries, which is, the evidence is not the strongest evidence, okay, in this case probably that anyone has ever seen, without commenting on the sufficiency issue, right?
certainly there are stronger cases.
Yeah. How should that weigh into it? The fact that the state tried twice to convince a jury and didn't really change the evidence or how the case was approached apparently in each of the trials, and then finally managed to get a jury to go along with the guilty verdict.
Well, Your Honor, I take 2 points to that. The first thing being, there are hundreds of reasons that a jury might, just one member votes to acquit. And they could range the gambit from completely logical to, I woke up on the wrong side of the bed. And that's just part of our process. And so, because there are two hung juries, I don't think that weighs at all into discussing the sufficiency or how strong the evidence of the state's case was. And so, And then two, the state here, this is a pretty large drug deal. I mean,
How many bites of the apple does the state get?
I don't think there's a magic number, Your Honor, but there's certainly realistic reasons. It's very expensive to try cases, as I'm sure all of us are aware. And so the state has to make that decision through its elected DA to decide how it's going to spend its resources, how is it going to prosecute people. And presuming it doesn't run afoul of these kind of the cherry discussion about race or discriminating on any of those other bad standards, they haven't violated that. This case here was 20,000 doses of methamphetamine being trafficked into North Carolina to go onto its streets. This is a huge drug deal that the state wanted to secure a conviction for on all to make sure that those who were involved with it were punished accordingly. And so they did retry it 3 times, a total of 3 times. And that was the state's prerogative. And the defendant produced no evidence to say that the state wrongly made that decision, that it relied upon some bad metric to do that.
So if we look at these cases, if we're supposed to look at these motions kind of individually based on each mistrial and the clock starts, should we as a reviewing court then look at each one of these motions and determine whether at any point in time along this way there was a speedy trial violation? You know, if your argument is, well, you know, you can only, you know, the clock starts again on mistrial. Well, what about the 24 months leading up to the mistrial? What about, you know, the 16 or 17 months in between there? What about, you know, so should we undertake an independent individual review of each of the mistrial motions, or is it the state's contention we only look at the last one?
Well, Your Honor, I think in the brief I talked about how this, or I guess they probably didn't make this clearly, this court's job here is not to necessarily strictly say the defendant's speedy trial rights at some point over the course of 5 years of litigation was violated. It is, did the trial court correctly deny his various speedy trial motions? And so we're sitting here and saying, okay, did speedy trial motion number 1, which was 24 months or so after the indictment, was his speedy trial rights violated? Okay, no, it's not. Let's move on. And so it is 4 separate motions that this court is reviewing. And because of that reset and timer, it's not this aggregating factor. So it is looking at it afresh with every new trial. Okay, did the defendant get violated? Did he not get the speedy trial rights?
And then looking at the last order, looking at the February 2021 order, can you articulate to me how the trial court in that case weighed the various factors in making its decision?
Well, Your Honor, I think it referenced the relevant case law, but again, this goes back to the defendant didn't present any evidence. He just merely stated and proffered these facts unsupported by any substantial hard evidence. So the trial court didn't really need to go through this kind of in-depth findings of fact because there were no disputes of facts. There was a delay between his indictment. They certainly had the information about what his previous trials were, but they didn't present any evidence to conflict with that kind of information. So there was no specific needing of the kind of granular findings of fact. The trial court said they weighed the various factors, and we have to take them at their word with that. And so and this kind of gets into the second Barker prong of reasons for delay. Our Supreme Court in Spivey was very clear that it is the defendant's responsibility to first make a showing that the state either negligently or willfully delayed the case, and then it's the state's burden to rebut that with various discussions. Now, I think, Chief Judge Stroud, you referenced kind of case law about how there is kind of this presumption per se. But that runs afoul of this kind of Spivey analysis, because in that case it was 4.5 years, and our Supreme Court said he relied on time alone as justification for a speedy trial violation, and the defendant didn't meet his burden on the second prong. So there can't both be this, our Supreme Court saying the defendant didn't meet his prima facie burden, and then this court saying lesser, I think 31 months is the one I was looking at, does kind of make this presumption. And so I don't think that Spinks is necessarily saying that. I think Spivey overrules that to the extent that it does. And so we have here no evidence. State didn't need to offer any evidence to rebut the non-existence of evidence, and the trial court probably denied. So we skipped it. So we're now at the kind of third prong of Barker, and it is in the brief that I do kind of concede that he did reference it 4 times over the course of litigation. So I'll only dwell on that briefly. And so we arrive now at prejudice. Now, the U.S. Supreme Court, our Supreme Court, have told us there's 3 reasons that we want the speedy trial. There is to prevent kind of the incarceration in general, oppressive incarceration, to minimize anxiety over a pending charge, kind of the sort of Damocles idea. And then there is the most important impairment of a defense. I did not see any cases where the defendant did not make a showing of impairment and yet still won the speedy trial, save Doggett, which was this kind of insane, unique example that doesn't really apply to this case. In Doggett, the defendant was indicted 8.5 years before his eventual arrest and adjudication. And in those 8.5 years, he left the country, came back, got married, I think he had kids, bought a house, got a job, and then some random check, they discovered, oh, actually you have a pending indictment that's 9 years old. And the Supreme Court discussed this and said, we have to just presume that over those 9 years where no one knew about this, somebody forgot something of importance. But that's not the case here. We have 3 different trials where the witnesses are getting refreshed their memories, they're remembering it at each one of them, and the state is making sure to keep its evidence safe. So there is no evidence that the defense was impaired, and he didn't, again, present any evidence to support that. And only relying upon this idea that if it was long enough, then it's just presumed, but we haven't met that. We're nowhere near 8.5 years, and we're certainly not near the unique circumstances of Doggett. And so, taking a step back, looking at all of these factors, we've got 3 of them are leaning in favor of the state, and only one of them is in favor of the defendant. And that is not enough to win on a speedy trial motion. And so, Your Honor, unless any of you have any further questions, I ask this court to affirm the judgment below. Thank you.
All right, thank you. Rebuttal?
Got a few points. One is on prejudice. First of all, U.S. Supreme Court law, which is Arizona and others, talk about the inherent prejudice for anyone who is waiting. That's the whole point of speedy trial, is you should be kept waiting. And if you're in jail while you're waiting, that makes the prejudice even worse. That inherent prejudice doesn't go away. It just gets worse as time goes on, right? And then there's the third way that someone can show prejudice, which is something happened to their defense that maybe they could have defended against it, and then a witness dies or something along those lines. That does not have to be shown. In fact, prejudice doesn't have to be shown, right? Going way back to Barker, there are 4 factors. None is necessary or sufficient, right? That's the standard language.
Do you think incarceration or lack of a trial after 1 year is presumptively prejudicial to shift the burden?
That does shift the burden, is my understanding. That's the case law say, approaching a year. And you know, we can say, oh, 2 months in jail, oh, a year in jail, what's the big deal? Well, that's a big deal. I don't want to go to jail for one night. You know, just because Mr. Ambriz is a drug dealer doesn't mean it's okay for him to sit in jail for 2 extra months. That's a lot of days away from his family, and 5 years.
When you look at the incarceration in relation to bond or the lack of bond, and I know there were federal charges involved here and also an immigration status as well, all of those things. You want to speak to that?
Well, that was the reason he couldn't get out on bond. I mean, he could have gotten out on bond and he would have been rearrested, and that is a fact. That doesn't stop the fact that he was in jail because of these charges, right? And there's a case in the brief somewhere that says, even if you're incarcerated doing other time, you still have a right to speedy trial. That doesn't take it away at all. And I wanted to get to Farmer, which is our North Carolina Supreme Court case that came down recently, and the prejudice analysis there. The factors there were all applied, and the balance is very different than it is here because there's a different, I think it was the assertion of right factor in Farmer that didn't exist at all. But I believe that our Supreme Court's analysis took a wrong turn because they talked about the inherent prejudice existing with anyone who's stuck in jail, and then they said that he didn't prove that there was something wrong with that his defense was hampered, and therefore this factor weighs negatively against the defendant. And I think that is clearly contrary to U.S. Supreme Court law, which, back to Barker, says there's inherent prejudice for anyone who is in jail. So I want to caution this court about, the Supreme Court gets to say North Carolina law, but the U.S. Supreme Court, tells you how to weigh the prejudice. And in addition to the inherent prejudice, Mr. Ambriz had this other federal charge that he could have been serving, and that was raised in the third and fourth speedy trial motions before the court. I wanted to ask if there is a remand for further findings. One other concern about that is that it's going to go back and sit around Guilford County for a long time, so if the court is thinking about that, it would be great to have some sort of time limit on that. Mr. Ambriz would certainly appreciate that. I want to talk about this being a complex case. That was another reason that I forgot to talk about. And the reply brief said there were 3 days of testimony. There were 9 or 10 witnesses. And even if it was complex before the first one, they did almost the same trial the second and third times, and there was no reason for that to cause delay. If there are no other questions, I would ask that you vacate Mr. Ambriz's convictions either on sufficiency of evidence or a speedy trial violation. Thank you.
Thank you very much. Thank you so much to both of you for your arguments. And we are going to take a brief recess now to switch panels, and so you get one more Campbell judge coming in shortly.
All rise. Stand in recess for 5 minutes.